In the next series of videos, we will be discussing one of the major issues involved in Halachic Estate Planning, and that is the issue of העברת נחלה, which in short signifies the question that all of the poskim have dealt with, those who've dealt with questions of Yerusha v'Zavon, i.e., to what extent are you allowed to disinherit an heir that otherwise would have inherited according to Torah law? In other words, we will see later on that there are techniques available which make it possible to create a will which is halachically valid and which will distribute the estate whichever way you'd like, and not necessarily to those who would have inherited under Torah law. The techniques exist. We've mentioned this already in previous videos. The question is, to what extent are you allowed to disinherit a Torah heir? The Torah, in fact, says, Ish ki yamut ubein ein lo va'avartem et nachlato lebito, which would seem to be a tzivui, that when a person dies, there is a commandment here. If he has no son, you give it to the daughter, which implies that if he does have a son, you give it to the son. But what happens if there's a situation where you don't want to leave your estate to the son, or you want to leave more to one son and less to another, or you want to leave part of your estate to your daughters alongside the sons, which again is not consistent with Torah law, as we've already seen. So the question is, to what extent can we take advantage of otherwise valid techniques which exist in order to create the estate plan that we want, even if it involves deviating from Torah law? As we will see, there are a number of sugyot in the Gemara which form the basis for any halachic discussion of this issue, and there are a large spectrum of opinions as to whether or not it is permissible to use halachically valid techniques in order to disinherit Torah heirs. And the spectrum is from one end to the other. In other words, there are those who hold that any such disinheritance is asur, forbidden, whereas on the other end we will see that there are poskim that find various arguments in favor of allowing total disinheritance of children, or kimat total disinheritance of Torah heirs, without invoking the isurim or the displeasure of the Chazal that we're going to see in a minute. So there is a wide variety of opinions, and everyone can find their comfortable position in that spectrum of opinions, as we'll see, all of which are based on the opinions of major poskim, such as Rav Moshe Feinstein, such as Rav Ovadia Yosef, such as Yibadlu L'chaim Tovim V'Arukim, Rav Zalman Nechemia Goldberg, and Rav Osher Weiss. Every one of these poskim has weighed in on this issue, and the opinions are varied. But in order to get into the sugya, we first have to learn a couple of pieces of Gemara, and we'll move on to the next slide. The first source that we'll take a look at is the Mishnah in Masech Bava Basra in Perek Yesh Nochlin, which says as follows: Hakotev et dechasav la'achirim. If somebody disposes of his assets to others, v'hiniach et banav. In other words, he gave his assets to someone else or to other people, and left his sons without any portion of the estate. Masha asasui. We're talking about a situation where during one's lifetime, for example, one makes halachically valid gifts. Let's say that a person is on his deathbed and he's learned the basic halachos, and he knows that a simple secular will is problematic, but he wants to give at least part of his estate, or even all of his estate, to those who are not Torah heirs. So he executes the deed of gift, makes a kinyan, and lifetime transfers are obviously valid. But as a result, the inevitable consequence of writing away one's assets by gift is that there's nothing left in the estate. So that when he dies, his Torah heirs his sons, for example, where he has sons, don't inherit. So the Mishnah tells us on the one hand that what he's done is done. Nobody can deny the validity of lifetime gifts. Ella, ein ruach chachamim nochai menu. It's an expression of displeasure. And when the Mishnah brings an expression of displeasure that ein ruach chachamim nochai menu, we have to take note. It's not just a nu, as we would say. Here, the Mishnah is expressly saying what you did is done, but it was not right that you should do it. Rabbi Shimon Gamliel Omer, on the other hand, im lo yu banav noagim kashura, zachor latov. In other words, if the reason that you are disinheriting your sons is because they are not behaving as they should, they were yored mi'aderech, they married outside the faith, whatever the reason that you feel that they are not living up to your expectations and therefore they are not ra'ui, they don't deserve that they should take a portion of your estate, and you want to make that statement in the way in which you divide your estate after your death, Rabbi Shimon Gamliel says, if lo yu banav noagim kashura, zachor latov, then adrabah. Not only is it not a case of ein ruach chachamim nochai menu, but zachor latov. Then he's earned his place in the Hall of Fame, as it were, by taking that courageous step and disinheriting a son who is not nohei kashura. It would appear in the Mishnah that there's a machloket here, because the Tanna Kama doesn't make any such exception. The Tanna Kama says, "Yiniach et banav, ein ruach chachamim nochai menu," and it doesn't matter what kind of son we're talking about. Rabbi Shimon Gamliel, on the other hand, steps back a bit, and he says that there is a case where we would not apply ein ruach chachamim nochai menu. It's a case where lo hayu banav noagim kashura. Rashbam on the Mishnah explains, ein ruach chachamim nochai menu, ein lechachamim nachat ruach mimaasav, ela charon af gorem lehen, shekoasim alav, deka'akar nachla doraita. It's not just that they're not happy, but they're koasim alav. Chazal are angry with him because he was oker in נחלה doraita. He removed the נחלה from where it should have gone, al pi Torah, and that causes ka'as in the eyes of Chazal. The Gemara wants to make sure that it understands correctly that the Tanna Kama is cholek, that Rabbi Shimon Gamliel and Tanna Kama are b'machloket, and it's not that Rabbi Shimon Gamliel is clarifying the opinion of the Tanna Kama. So the Gemara asks, it opens with that question, Ibailu. Is this a case where Rabbi Shimon Gamliel is where the Rabbanan are cholek Rabbi Shimon Gamliel? Are they of the opinion that even if a ben is not nohei kashura, nevertheless ein ruach chachamim nochai menu if you disinherit him? Olo, perhaps Rabbi Shimon Gamliel is just clarifying what Chachamim also believe to be true. Toshma, Gemara brings a raya. The Amalei Shmuel Rabbi Yehuda. Shmuel once said to Rabbi Yehuda, Shinina, you're a sharp Talmid Chacham, but listen to me. Lo tehevei bei avur achsanta. You should not be among those who transfer their estate. In other words, they're oker their estate from the Yorshei Torah. Va'afilu, and here's the point. Va'afilu mibra bisha libra tava. Even if you're doing it because you want to move the estate from a bad son to a good son, literally in the translation. Kolshke mibra librata. If you're transferring the estate to a daughter where there are sons, then clearly that is not acceptable. So what do we see here? The ratio of Shmuel's statement to Rabbi Yehuda, afilu mibra bisha libra tava, asur lecha to disinherit. And as the explanation is given, because you cannot know what ultimately will transpire as the generations progress. The son may be brabisha, but that doesn't mean that the grandson will be a brabisha. And by cutting off the estate from your son, you basically make it impossible for the estate to ever end up in the hands of your tzeitzayim, who may very well not be brabisha at all. And I'm sure we're all familiar with situations where the first generation is not kashura, and then the second generation is mitchazek, and ultimately there would be no objective reason to deny the grandchildren and the rest of the family in the generations that follow from enjoying their share of the estate. So that's one point. So the point here is Ein ruach chachamim lo chai menu, no matter what. The second point that we see here in the Mishnah is the nusach of the Mishnah. Kotev et nechasav lacharim v'hiniach et banav. If you say v'hiniach et banav, it would seem to imply that you disinherit the sons completely. You leave them outside of the distribution of the estate. What happens if you just want to increase one son's share at the expense of another's, for which there may be very legitimate reasons? Let's say that one son has made a very profitable exit, and he is misudar l'chaim, and you have another son who's having difficulty making a living, or there's an illness in the family, or some other reason that objectively is quite justified, whereby you would want to benefit one son more than another. Is that also a case of ein ruach chachamim lo chai menu? Because the Mishnah would seem to imply that that's not the case. Because hiniach et banav would seem to imply that you disinherit your sons altogether. Says the Rashbam, be'avur achsanta, which is the language that Shmuel used, lo tehevei be'avur achsanta, you should not be oker, the Yerusha, makom shema'avir ha'av נחלה min hara'uila, afilu l'harbot le'echad v'lema'et le'echad. The Rashbam says beferush, you shouldn't interpret the hiniach et banav that narrowly. Hiniach et banav means that you give them less than they otherwise would have gotten. Even if one son gets his share and gets more than his share, and another son gets something but less than his share that he would have inherited if he had inherited al pi din Torah, which means an equal share. Even that, according to the Rashbam, is a be'avur son. And as we'll see as we move on in the sources, that opinion of the Rashbam is a very, very machmir opinion, and we'll see that there are other Rishonim and Poskim who don't agree. That to give more to one and less to another is not a case of avur achsanta. It is not a case of akirat נחלה, and it is not a case of ein ruach chachamim lo chai menu. But we'll see that as we move on. The next slide, we'll see the Yerushalmi's opinion about akirat נחלה. The Gemara of the Yerushalmi, which is the Gemara on the same Mishnah that we saw in the previous slide. Amar Rava bar Mama, hakotev nechasav la'acherim ve'iniach et banav, alav hu omer v'tehi avonotam al atzmotam. The Gemara there doesn't use the language of ein ruach chachamim lo chai menu. It's a Mishnah, but the Gemara states the case even more severely. V'tehi avonotam al atzmotam. And the Pnei Moshe explains there, sheha'avon kayam al atzmotav ba'kever le'olam. That's a much more serious statement of displeasure. It's not just ein ruach chachamim lo chai menu, but there is an avon which is kayam al atzmotav ba'kever le'olam. It's a serious description. If we check in all of Shas to see how this pasuk v'tehi avonotam al atzmotam is applied, we'll find that there's only one additional place in Bavli, in Masechet Ta'anit, where the Gemara discusses the Seudah HaMafseket before Tisha B'Av. And the Gemara there says that someone who eats meat or drinks wine in the Seudah HaMafseket will not be zocheh to see the Geula in Yerushalayim. And there too, the Gemara says, as the pasuk says, "V'tehi avonotam al atzmotam." It would seem that if one doesn't mourn the Churban Abayit, and he's basically detaching himself from Klal Yisrael. He's detaching himself from one of the most fundamental ideas of Am Yisrael, and that is the mourning for the Churban. And if you eat meat and drink wine at the Seudah HaMafseket, then clearly you're detaching yourself from Am Yisrael. It would appear, therefore, according to Yerushalmi, and as we've seen in the previous video, one of the ideas of Yerusha al pi din Torah is the Hishtalshalut HaDorot, is the continuity, that the son takes the place of the father, that the son is basically in the shoes of the father, and even has his identity, which is one of the major ideas of the continuity of Am Yisrael from the Churban and onwards until the Geula Shlema. Therefore, the Yerushalmi is of the opinion that if one disinherits his sons, he's basically cutting off the continuity which is reflected in the idea of Yerusha al pi din Torah. And that's why it uses this pasuk of v'tehi avonotam al atzmotam. Be that as it may, We now see that the starting point for any discussion of halachic estate planning must take account of this problem. How is it that we can use halachic techniques, which we'll discuss in a future video? How is it possible to use these techniques and disinherit the Torah heir if we have such serious statements by Chazal against doing exactly that? We saw in the Moreh Nevuchim of the Rambam that the Rambam is talking to the potential testator before his death and telling him it would not be ra'ui that he should give away his assets and deny his family the economic stability which they enjoyed during his lifetime. But the Rambam is talking to the conscience of the testator, which would seem to be in line with the Mishnah's approach of Ein Ruach Chachamim no chai menu. It's not an isur, but it's something that the Chachamim look askance upon. But if we talk about Vati avonotam al atzmutam, the Pnei Moshe says befirush that it's an avon that's kayam al atzmutav, then it would seem to be not only this Ein Ruach Chachamim no chai menu if you do it, but it would seem to be asur to do it. The Gemara Ksubis Daf Nun Bet Amud Bet. Gemara tells us as follows: Amar Rabbi Yochanan, Mishum Rabbi Shimon bar Yochai, Mipnei Ma Hitkinu Ktubat Benin Dichrin. Ktubat Benin Dichrin is an inseparable component of the Ktubah, and basically it says as follows: let's say that a person gives his daughter an ample dowry, and she marries. If she was to die after giving birth or after having children, and the husband is alive, the husband would inherit. Bal Yoresh et Ishto. Now the husband remarries, he marries again, and he has additional sons from the second marriage, and then he dies. Who inherits that dowry that the husband had received from his first wife's father? The dowry becomes part of the husband's estate. Now all of the sons of the first wife, the sons of the second wife, they are all heirs of the husband, and so they would all inherit equally. As a result, the sons of the second husband, who have no connection to the first wife, would end up inheriting a portion of the dowry that the father gave the first wife. That caused fathers to be hesitant to give their daughters significant dowries because they were afraid if the daughter dies first and then the husband remarries, ultimately children who have nothing to do with him, who are not his grandchildren, would end up inheriting a portion of the dowry that he gave his daughter. So Chazal were metakein a ktubat benin dichrin, the ktubah of banim zcharim. What it means is that to the extent that a father gives his daughter a dowry and she dies before her husband, and ultimately, when that husband will die, the amount of the dowry will be inherited only by the first wife's sons. The second wife's sons would not take any share of that dowry. That's Ktubat Benin Dichrin. Clearly, if you think about it for a second, the Ktubat Benin Dichrin is inherently a takana which disinherits Torah heirs. Because al pi din Torah, all of the husband's sons ultimately are supposed to inherit his entire estate, which includes also the dowry from the first wife. And by being mitaken takana, that only the sons of the first wife will take the nedunya that the first wife's father gave her, the sons of the second wife don't take any share of it. And that is against Torah law. According to Torah law, all the sons of the husband should inherit everything equally. We'll see how the Gemara deals with that issue. But first, the Gemara asks more fundamentally, Mipnei ma nitkinu ktubat benin dichrin? Why did Chazal? What is there such takana? The Gemara answers, Kadeshi yikpotz adam v'yichtov lebito kibno, so that a person should have no hesitancy. He should keilu literally jump at it to give his daughter an ample dowry, because he doesn't have to worry about any foreign grandchildren ultimately taking a share of the nedunya. Preserves the nedunya to the particular heirs of his daughter and not to any other sons the husband may subsequently have. Gemara asks, Mi ikamida. Midi. Is there such a thing? The Rachmana Amar Bra Lirod, Brata Lo Tirod. The Torah says that a son should inherit and a daughter should not inherit. Atu Rabbanan umetakni the Tirod Brata. And then Rabbanan come along and they're metaken that the daughter should inherit. It doesn't mean exactly that the daughter's inheriting. We're talking about a daughter who predeceases her husband. But it means the children of that daughter, they will inherit exclusively to the exclusion of the children of a subsequent one. The Gemara says, Ha nami doraitahu. The encouragement that Chazal intended by making this takana, the encouragement of fathers to give dowries to their daughters, is also an equivalent consideration which the Gemara even calls doraita. Why? So the pasuk here, which is not a pasuk in Torah, it's a pasuk in Nevi'im, but the pasuk tells us that it encourages fathers to marry off their daughters. So the Gemara says Bishlam al Banim. The idea here, K'chu livnechem nashim, that's b'yadei kaima, that's within his power to bring about, because sons can pick their shidduch, and the father can support the son's choices. But aval bante mikaima b'yadei. But what about daughters? Is that up to him? When a father has a daughter, and how can the pasuk be telling him that benotechem tenu lanashim? It's not just up to him. He's got to find a family that is willing to give their daughter to his son. So the Gemara says, Hakamash Malan. So therefore the pasuk comes along, the Chazal come along and tell us the Nilbishe that we should give her a wardrobe. The Nichse, we should give her Nechasim, assets. The native Lemida. And give her sources of sustenance. In order that prospective grooms should jump at the shidduch, and they'll come and they'll marry her. So therefore, we see that the shikul, the consideration of encouraging dowries as a means of making sure that daughters can get married, is based on this pasuk of et benotechem tenu la'anashim. And the Gemara says that is a consideration that is equivalent to Havaras נחla. Ad kedei that the Gemara calls it Hanami Doraita, even though, as we've seen, the pasuk is not a pasuk in Torah, but in the Navi. So the Gemara asks now, you want to tell me that even if you entirely disinherit the sons of the second wife, they won't inherit anything at all? That would seem to negate the whole idea of Yerusha al pi din Torah. So the Gemara answers, if the result of Kedubat Benin Dichrin is that the second sons inherit nothing, let's say that the husband inherits the Nidunya that the first wife's father gave her, and then has no additional assets when he dies, even though he remarries, so that the sons of the second wife will inherit nothing, according to this takana. The takana says only the sons of the first wife take the Nidunya. What about the sons of the second wife? What if there's nothing left aside from this Nadunya? Would that also be acceptable as an application of the takana? The Gemara says no. If the result of this takana is that Nachla Doraita should be ne'akeret legamre, then lo takin rabbanan. Then the takana will not apply. There has to be at least something that the sons of the second wife will also inherit. This becomes a very, very significant component of the halachic considerations in Ha'avarat נחala. We see here from this Gemara, number one, that if there is a legitimate consideration which dictates that one should give part of one's estate in some other fashion rather than to the sons, it's possible. Here, it's a takana of Chazal. It's not an individual decision by the individual testator. We'll have to see how that works out. But at least here we see the Chazal. We're open to the idea that we could take away at least part of the Yerusha of sons that otherwise would inherit al pi din Torah because of equivalent consideration, which is to make sure that the daughter can get married. On the other hand, Chazal were not willing to enact such a takana in a case where the other sons would not inherit anything. There has to be some transmission of one's estate al pi din Torah. Then we can talk about the rest. And here the Gemara says a motar dinar, which is arba zuz. It's not a very great sum of money. So what's the point? That's what makes the difference. If the sons of the second wife will inherit a motar dinar, that's the difference between akirat nachala yes or akirat nachala lo. The answer is there's a symbolic value in this motar dinar because it preserves the process of Yerusha al pi din Torah. The sons will inherit at least something, and they can therefore be classified as Yorshim B'fa. As we'll see as we progress, this idea of motar dinar has gone through a number of permutations in the opinions of various poskim. But for the time being, we've seen here that the Gemara establishes the principle that there may be other considerations which make possible Havarat Nachala. There's one more piece of Gemara, which immediately upon this one, which is in the next slide. The following piece of Gemara, which follows on the previous one, tells us the following story. Rav Papa was engaged in setting up a shidduch for his son, Be'al and he came to Surah to discuss the terms with the Kala's father. He went there in order to write the Ketubah. Shama Yehuda bar Merimar heard that Rav Papa was in town, and Nafik Atayit Chazale. So he went out to see him. Kimata lepitcha, but when they got to the door of Be'aba Surah, Havakal Mifter Minei. Then Yehuda bar Merimar stepped aside. He didn't want to go in. Amalei, so Rav Papa says to him, Neil Marbadeh, Kodo should come in with me. Chazia de lo habanichale. Rav Papa saw that Yehuda bar Merimar was hesitant, was uncomfortable with going inside. Amalei, so Rav Papa said to him, My daitech, what's the reason? What is your opinion? Why don't you want to come in? Is it because Mishum Damalei Shmuel Rav Yehuda Shinin alo tevi b'avur santa? Is because of what we saw earlier in the Gemara that Shmuel says to Rav Yehuda that you should not be oker nachala afilu mibra bisha afilu from a bad son libra tava to a good son. The lo yadia ma'izar nafik meneh. Here we add that little piece that we said previously, that the reason you're not allowed to take away a Yerusha, even from a Brabisha, is because the lo yadia ma'izar nafik meneh. We don't know what kind of children will ultimately result from him. The koshke mibra lebrata, from a son to a daughter, is called a chomer. Is that the reason that you don't want to come inside, because you don't want to lend legitimacy to the very fact that an adunya is being given here? So the Rav Papa says that shouldn't be a reason not to come in, because Hainami Takanta Rabbanani, this is also a Takana Rabbanan, Damar Rabbi Yochanan Mishra Shubo Yochai, which is the Gemara that we saw earlier, that Chazal want to encourage the giving of an adunya, and they therefore even when Mitakenik Tubat Benin Bichrin, which sets the stage for encouraging fathers to give nadunyas to their daughters. So why would you be objecting to it? Amalei, so Yehuda bar Merimar said, that is all true if the father gives the nadunya from his own free will. But is it also true where he's being coerced? Because Yehuda bar Merimar thought that Rav Papa was perhaps asking him to come in with him in order to enforce a giving of nadunya on the part of the daughter's father. So Rav Papa says, Mapito. Amalei. So Rav Papa says to him, Atu mika aminalach, did I say to you, the old vasiyah, she should come in and enforce an nadunya against the father? He said, oh, lo das tasiyah kamina, I just told you to come in, I didn't ask you to enforce anything. Amalei. So Rav Yehuda bar Merimar says to him, it's not enough, because Malai Didi, my etzim coming into the house, Hainu Asiyah, that's already a form of coercion, because the daughter's father won't be able to say no when a significant Gadol B'Torah is there and overseeing the whole process. He felt his very presence would cause the father to give more than he otherwise would have agreed, because he'd be mitbayesh b'fanai or some such consideration. But Rav Papa wouldn't give up. Rav Papa achfie. Papa pretty much forced him. Said, no, I'm not moving until you come in with me. And he said ultimately he did come in. He came into the house, but because he didn't want to force Abba Surah to do anything, ishtik, he kept quiet, and he sat there, but he didn't say anything. Savar, but the very situation caused the Abba Surah to believe that why is it that Yehuda bar Mrema is being quiet? Is because Mirtach Ratach, because he's mad at him. He's mad at him that the Nedunya isn't good enough. That's what he thought. He thought that Yehuda bar Mrema was mad at him that he wasn't. Yehuda bar Mrema didn't want to make him believe that he had to give anything, but the father misinterpreted his silence as anger, ki'ilu that he didn't give enough. So katve lekol ma'id havale, and so he wrote over to his daughter everything that he had, which is the opposite result of what we would have wanted to happen. With this, as a misinterpretation of Yehuda bar Mrema's silence. Solve when the negotiation was finished and the ksuba was written and he had written over everything to his daughter. Amalei Abba Surah said to Yehuda bar Mrema, "Hashtanami lo mishtaymar." Even now you're not speaking to me. You're not saying anything. I mean, I did what I understood that you wanted me to do. I wrote over everything to my daughter. Even now you're not speaking to me. So Amalei, if Yehuda bar Mrema says, "Iminai didi," if you would have asked me for my opinion, you would have asked me for an eitzah. Afilu haynami de katavto nichali. Even what you wrote, נחלה, before you wrote over the sum and signed over everything. Even that would have been too much if you would have asked me. Lo nichale. Amalei, Abba Surah said, if that's the case, hashtanami adabi. So I will be choser bi. I will retract my more generous offer, because the only reason I was posek such a large sum is because of you. And now you're telling me that I misunderstood completely what you intended. And so I'm going to go back to the original proposal. Amalei, so Yehuda bar Mrema said, Shavya nafshach hadrana lo kamina. Shavya nafshach means I didn't intend for you to be choser b'cha from what you ultimately agreed to. Would have been okay if you would have asked me earlier. It was not my kavanah that you should be choser b'cha from what you agreed to ultimately, but only that you shouldn't have. Okay. So basically, Yehuda bar Mrema says, now that you agreed, you can't go back. So here we see a complicated situation where there are various opinions as to what is appropriate in giving an adunya to a daughter. Yehuda bar Mrema was of the opinion that it's illegitimate bichlal. Papa, on the other hand, supported the idea that Chazal, in fact, were encouraging the giving of an adunya, in spite of the fact that ultimately the giving of an adunya to the daughter in the context of Ketumat B'nim Dichrin ends up disinheriting the sons of any subsequent wife, who otherwise would have inherited it. These Gemaras, first the Gemara in Baba Basra, where we saw the Mishnah, Ein Ruach HaChomim Nocha Imenu, and this Gemara in Masechet Ketubot that does open a petach for disinheriting sons in favor of daughters, where the purpose is to facilitate a shidduch, but on condition that at least some sum is left to the Torah heirs. This becomes the framework for everything that follows in this sugya. And we'll stop here. In the next video, we will continue the study of these sources. I would point out that there's a link below where you can download the source sheet, which is a number of pages that you can have with you while you're reviewing the sugya and while we are learning the sugya through the slides that you see in front of you.